Hi there, Doc from BarcastAudio here today to talk with you about another bar exam question of the day. I'm not going to tell you what the subject is. I want you to identify that for yourself. Until then, let's jump right into the question. So be sure to go to BarcastAudio.com no matter where you are in your bar exam prep. We have audio outlines, audio flashcards, essay attack sheets, essay workshops, everything you could possibly need to pass the bar exam. If you're overwhelmed right now, we got it over there for you. If you're looking for tutoring, email in the link below. We have everything you need over there. So be sure to check us out over at BarcastAudio.com. Before that, or until then, let's get into the question. Okay, so today's question is as follows. A seller and a buyer execute an agreement for the sale of real property on September 1, 2001. The jurisdiction in which the property is located recognizes the principle of equitable conversion and has no statute pertinent to this problem. Assume for this question only that the seller dies before closing and his will leaves his personal property to a friend and his real property to his sister. There being no breach of the agreement by either party, which of the following is correct? A. Death, an eventuality for which the parties could have provided, terminates the agreement if they did not so provide. B. The sister is entitled to the proceeds of the sale when it closes because the doctrine of equitable conversion does not apply to these circumstances. C. The friend is entitled to the proceeds of the sale when it closes. D. The title was rendered unmarketable by the seller's death. Okay, so what is this question testing? This is obviously testing real property once again. What's really being asked of you here is understanding of equitable conversion, understanding of when a party's rights in property sort of take hold, and how that all kind of works and the timing of all that. It's a little bit complicated, so I want you to pay close attention here. So the correct answer to this one is actually C. The friend is entitled to the proceeds of the sale when it closes. And the reason for this is very simple. When a real estate transaction occurs, the period between contracting and closing is governed by the doctrine of equitable conversion, meaning that once the contract is signed, the risk of anything happening to the property is transferred to the buyer themselves. So if the property burns down before the closing, the buyer sort of carries that risk. And the reason for this is that through the doctrine of equitable conversion, the title has effectively passed at that point from the seller to the buyer. So what the seller then has is not an interest in the property itself, but an interest in being paid for the proceeds of the sale of the property. Meaning that when a seller dies before closing, in between contracting and closing, their next person in their estate does not have any interest in the property itself because that has been transferred already. They have an interest to be paid for that property. So whoever was in charge of the estate at that time, whoever was the seller's estate, would then take an interest in that sale. So here what gets confusing is that the seller left an interest in his real property at the time of his death to his sister, and in his personal property at the time of his death to his friend. So the sister would take only what real property interest the seller had at the time of his death. And the seller had no property interest, real property interest at the time of his death. Instead, he had a personal property interest, and that personal property interest was actually in the monetary funds to be paid out upon the sale of his property. It's a complicated issue, but the reason for that is that's the reason why the friend here would be entitled to the proceeds of the sale, even though the sister technically was entitled to any real property interest he had at the time of his death. It's complicated. It's a complicated issue, but ultimately what you need to understand is that if a seller dies in between the time of contracting and the time of closing, their interest in real property does not pass to their estate because that they don't have an interest in that real property anymore. They have an interest only in getting paid, which is a personal property interest. Be sure to check us out at BarcastAudio.com for audio flashcards, more in-depth sort of analysis of some of these property law issues. Until later, I'll talk to you guys soon. Bye now.